facing the police every single day.
Andrew Sheets arrested again on probation violation. By Frank DeFury, staff writer, June 14, 2022. 1. PUNTA GORDA. Less than a week after his conviction, Andrew Sheets is again under arrest. Charlotte County deputies arrested Sheets on Monday, charging him with 2 counts probation violations. The arrest came 3 days after a Charlotte County jury found Sheets, 57, guilty of breaching the peace and disrupting an educational institution. The original trial centered around an incident where Sheets was protesting outside the Sally Jones Elementary School campus. He held a sign with pictures of aborted fetuses and was wearing a shirt that read "F abortion" while parents were dropping off students. Witnesses said Sheets got into heated arguments with parents leaving the campus, which led to backed-up traffic and students being late to school. One parent allegedly became so frustrated at Sheets that she attempted to drown out his voice with a bullhorn siren. During the trial, Sheets' attorney Lee Hollander argued his client never set foot on the school grounds and made no attempt to physically compel parents to remain near him. He also argued the case could have a chilling effect on free speech, echoing his client's avowed advocacy. Judge Peter Bell withheld adjudication in the case, predicated on Sheets completing 12 months of probation and 100 hours of community service. The probation also stipulated that Sheets would not be allowed to access firearms and avoid contact with Sally Jones Elementary School. According to court documents, Sheets is alleged to have posted a YouTube video on the same day he was sentenced, where he called on others to protest outside Sally Jones. "I recommend everybody come down here and go to Sally Jones School. Just come to Punta Gorda and do your free speech, because it is completely out of control here," Sheets said in the video. After probation warrants were issued for Sheets, deputies found him on Pepperdine Street. Sheets told deputies he had made arrangements to surrender firearms that he owned to a friend. He also told them he had a handgun in his car. Deputies found a pepper ball gun. Deputies arrested Sheets and took him to Charlotte County Jail. He was held Tuesday afternoon with no bail. Court documents show Sheets has filed to be considered indigent and is awaiting a court-appointed lawyer. In the same video, Sheets disparages his former attorney for ineffective counsel during the original trial. Sheets also claimed Bell and the jury were biased against him due to the circumstances of his original arrest, particularly his use of obscene language and additional protests against police. The Daily Sun reached out to Charlotte County Public Schools regarding the video from Sheets' channel. Community liaison Mike Riley said that he does not anticipate that the video will inspire much action, but the school district remains vigilant about protecting its students. "The community loves this school," Riley said Tuesday. "I can't believe anyone in the community would be interested in doing something like that." Bail law came to North America with the English legal traditions. Even before the adoption of the U.S. Constitution and the Bill of Rights, a Judiciary Act in 1789 guaranteed a right to bail in all non-capital cases. For a person charged with a capital offense, where death is a possible punishment, bail was discretionary. It depended on the seriousness of the offense. The Eighth Amendment to the U.S. Constitution states that excessive bail shall not be required. Regardless, the Supreme Court has ruled that the U.S. Constitution permits holding a defendant without bail in some circumstances. In other words, while bail is a constitutional right, it is not an absolute right. Current bail practices are unconstitutional because they violate the rights to due process and equal protection under the 14th Amendment, the prohibition against excessive bail found in the 8th Amendment, and the right to a speedy trial guaranteed by the 6th Amendment. Widman Act, named after fallen Fort Myers officer, to become law. By. Published on May 4, 2011. The third time was the charm for the Andrew Widman Act. After failing to pass through the legislature the last 2 years, the bill, which is named after the slain Fort Myers police officer and designed to give officers and judges the necessary tools to keep repeat violent felony offenders off the streets, is now heading to Governor Rick Scott's desk to be signed into law. The Florida House passed the bill 115-1 on Wednesday. The only holdout, Representative Betty Young, D. Tampa, switched her vote after roll call. The Senate unanimously passed the bill last week. Freshman Representative Matt Caldwell, R-Lehigh-Acres, who sponsored the bill in the House, called it his greatest success so far as a lawmaker. He also credited Senator Lizbeth Benequisto, R. Wellington, the Senate sponsor, as well as his predecessor, Nick Thompson, who carried the bill the previous 2 years in the House. Officer Andrew Widman was gunned down by a violent felon who should have been in prison because of the violations of his probation, Caldwell said on the floor. This bill will address that concern. The House passed the bill every year since it was first introduced in 2009, but it has never made it out of the Senate until this year. Susanna Makinson, Widman's widow who remarried last summer and moved out of state, cheered when she was told by a reporter of the bill's passage. "It's wonderful," she said. "I know these things take time. I think it happened pretty quickly actually. Some people need a lot longer for legislation that is important to them." Widman's name will now signify the protections that all Florida officers and citizens deserve, something that his family can be proud of, Benequisto said. "We look forward to the governor's signature and letting Widman's family know their sacrifice has created a lasting legacy," Benequisto said. Widman, a one-time Christian minister who had been working as a Fort Myers police officer for just over a year, was gunned down by a career criminal while responding to a domestic violence call in downtown Fort Myers on an early morning in July 2008. His killer, Abel Arango, had recently been arrested in Lee County on drug trafficking charges, a violation of his probation. Only after he was released on bail was a warrant, with a no-bond provision, issued for his arrest for violating his probation. Despite the warrant, Arango managed to walk out of a Lee County courtroom after making a first appearance in the drug case. In the case of a probation offender being arrested on a new charge, the Andrew Widman Act would allow a first appearance judge to immediately issue an arrest warrant for the probation violation. If signed by Scott, as is expected, it would go into law on July 1. Fort Myers Police Chief Doug Baker called the Widman Act a no-brainer for Florida, but said it's unfortunate it took 3 years to pass. "It will help bring closure to his department," Baker said, "but more importantly, it will help save lives by keeping violent offenders behind bars. I'm very humbled and honored that our officers' name is attached to legislation that is going to protect and save the lives of future law enforcement officers in the state, and community members," Baker said. "For us, we are never going to forget Officer Widman's sacrifice. 10 Florida law enforcement officers have died or been killed in the line of duty so far this year, 6 by gunfire, according to the Officer Down Memorial Page website. The Widman Act could help prevent future law enforcement killings," Caldwell said. "We've lost more than a half dozen officers this year that very well could have not happened if we had had this in place already," he said. "All of those killers were violent ex-felons who should be behind bars." Makinson said passage of the legislation is a good thing that she's wanted to happen, but said she didn't believe it would bring closure. "I don't know how any form of legislation could do that," she said. "It's never going to bring Andy back. It's never going to heal my children. That's something that really only God can do, and really it takes a lot of time." Connect with Ryan Mills at www.naplesnews.com/staff/Ryan-Mills. What is Florida's Widman Act? What is the Widman Act in Florida, and how does it affect my violation of probation case? Widman Act. I recently learned of a Florida law known as the Widman Act because of a recent violation of probation case I handled. A client who I represented on a pending Sarasota violation of probation case was out on bond waiting for his next court date when he was arrested for a new criminal charge in Charlotte County. Although he had a relatively low bond on the Charlotte County criminal charge, the Charlotte judge ordered that my client be held with no bond under the Widman Act. The new arrest in Charlotte County technically violated his Sarasota probation. The client was held for several days with no bond, and later transported to Sarasota County where he was brought before the first appearance judge. The Widman Act was a law passed in 2011 by the Florida legislature, and is now part of Florida Statute 948.06, 1, c. The law was named in honor of a Fort Myers police officer, Andrew Widman, who was killed by a person who had a lengthy criminal history and an active warrant for violating his probation. The Widman Act law states that if a judge finds reasonable grounds to believe that a probationer or an offender has violated his or her probation or community control in a material respect by committing a new violation of law, the judge may issue a warrant for the arrest of the person. A judge at the first appearance or advisory hearing does not have to be the judge who actually presides over the case to issue the warrant, and does not have to wait for the probation officer to file a violation of probation affidavit. In other words, the judge who presides over the first appearance hearing can on his or her own motion order that the defendant be held in custody for a violation of probation, even though the court itself may not have jurisdiction over the violation of probation case. I have to admit that where I normally practice, Sarasota and Manatee counties, we do not use the term Widman Act. I would go even further to say that I have never had a prosecutor in Sarasota or Manatee ever ask for a hold under the Widman Act, even though the law has been in effect since 2011. When I went to my client's first appearance in Sarasota, I did feel a little better about myself when the presiding judge over the video asked aloud, "What is the Widman Act?" Since this case I have done quite a bit of research on the Widman Act to better educate myself. If you have any questions about your violation of probation case, or need further information regarding how the Widman Act might affect your violation of probation case, please feel free to call me for a free no-obligation consultation at 941-954-5333. Damages awarded. Trezevant v. City of Tampa, 741 F2D 336, 11th Sir 1984. Motorist illegally held for 23 minutes on a traffic charge was awarded $25,000 in damages. Sets foundation for $75,000/HR, 1,800,000/day.
Please be seated. Does the state have any factual information for the court to consider or any sentencing recommendation at this time?
Yes, Your Honor. As it relates to count one, we've asked for adjudication of guilt, 15 days in the county jail, 5 months of reporting probation to follow, obviously cost of court, cost of prosecution, $100 on the, or $50 on the prosecution, no contact with any school, be it private or public. And as it relates to count two, a consecutive 6 months of reporting probation with no contact with any school, private or public.
Any factual information from the defense or any sentencing recommendations at this time?
The only factual is he's got 0 priors, Judge. So I was going to ask the court to withhold on both counts and give him 6 months probation concurrent or even 12 months consecutive. The court heard the facts of the case. And like I said, he's got no prior, so I'm asking for a withhold on both counts. Thank you.
All right, at this time, Mr. Sheets, having received the jury's verdict, they have made a determination that they believe that the way you were treating the parents at this particular school was of a nature to corrupt the public morals or outrage the sense of public decency or affect what is indicated as the peace and quiet, which is to say the physical safety of those parents. There does not appear to be any evidence to suggest that you did engage in brawling. However, one would have to question whether or not the young lady's response with the bullhorn was, in fact, an act of battery against you, given what was indicated on the video, where there was an indication that it was hurting your ears, which is a physical response by her against you in defense of herself and the way she was being treated by the words that you were using on the date in question. That is the classic breach of the peace, where someone is so affected by words that they attack another person, and that is what she did. She attacked you, although she did it with a very loud sound device. That is nonetheless a battery and could be charged as such, but for the fact that she would have that defense, that she was defending her honor. She was engaging in that conduct because she was incited by fighting words, and therefore likely she wouldn't be convicted. But that is part of the analysis of the court. I don't think that the jury necessarily engaged in that deep analysis, but they certainly found that under the definitions provided to them, you had done something that was inappropriate by definition of our legislature. Given that you lack a prior record, I am going to grant your attorney's request, and on count one, withhold adjudication. You will be placed on a term of 6 months of probation, and as a result of your conduct, you will be required to do something that would benefit your community. As a matter of fact, you're going to be required to do a total of 100 hours, 50 hours on count one, 50 hours on count two of community service. Things that will benefit your community by helping some nonprofit, church, or charitable organization by being a benefit to them for that amount of time over the course of this 12-month period. 6 months on count one, plus the court costs that apply to this case. $220, and the $50 cost of prosecution. On count two, there is that adjudication, 6 months concurrent probation, consecutive probation, 50 hours of community service. All your community service hours have to be completed before the end of that probation, which is to say 5 months and 10 days into the probationary period. Additionally, I will put an order in place that you not have contact with Sally Jones Elementary School. It appears most appropriate, given what occurred in the case, that the students and parents wouldn't be subjected to your presence for a period of 1 year. 6 months and 6 months, no contact with Sally Jones during those time periods. Which isn't a prohibition against driving by if you need to go up Cooper Street and go, one place or another in the community. What it's a prohibition against is communicating with people at the school or going on school property. So if you were to say, for example, position yourself across the street, which is a way of communicating, hey, remember me, that would be inappropriate. But if you just drive by because you're going to the Ann Street storage facility or something by way of those roads, that's not prohibited. It's the contact and communication with the school that is prohibited, or going on that property. I'm not going to put a blanket prohibition against all schools because they weren't subjected to this conduct, and it doesn't appear necessarily that you are focusing on schools, although I understand the argument that you position yourself near a school to get adults. You certainly can do that at other places, and that's not going to be prohibited. What's prohibited is the type of interaction between yourself and the adults while you were engaging in free speech. And it's certainly not inappropriate to engage in free speech, but the way you treat the people in which, with whom you're engaging is what was found unacceptable by this jury. You would have 30 days to appeal if you think anything illegal occurred to you from your initial contact with law enforcement all the way through sentencing. If you want an appeal filed, you just tell your attorney, and it has to be within 30 days. If you let the 30 days come and go and it's not filed, then your appellate rights expire. If you tell your attorney you want an appeal filed, he will do that because he'll remain attorney of record, and that will be part of his professional responsibility. However, it is not his responsibility to represent you on appeal. If you want him to do that, you'd have to make professional arrangements with him. If you're unable to afford appellate counsel, you can apply at the clerk's office. There's an application for criminal indigent status form that you can get from our clerks. You can fill that out and submit that for appellate counsel, and they can see if you qualify for that. That also would need to be done fairly expeditiously, so that once your appellate documents are filed, your attorney, if you need a public defender, can then get on board as quickly as possible to assist you. We're going to give you your sentencing paperwork, and you'll need to, within the next 2 business days, which will be Friday or Monday, contact probation. Your phone number for probation will be on this sheet. So just give them a call and they'll guide you with regard to reporting in. And count 2, and the monies are due within 5 months and 10 days.
Would cost $215.
$215, yes, and the $50 cost.
Judge, did you adjudicate or withhold on count 2?
There's a withhold on count 2.
Thank you.
No prior record, so that's why that's being done at this time. All right? And the community service is to benefit the community based on this conduct.
And that was on which count, Judge?
Each count has a separate set of 50 hours to be completed
Oh, okay, I see.
within 5 months and 10 days from the commencement of probation on that count.
Got it.
All right? Certainly, if there's a willful violation of this probation, then of course there'd be additional sanctions, which could include jail time. So, Mr. Sheets, I'm sure, will conduct himself accordingly. Sir, we'll give you this paperwork, and then you're free to go, and you need to make sure you contact probation within the next 2 business days. Court will stand in recess.